I think your suggestion is that we're able to work with them to set a date.
Well, what kind of work is this? This is on the agenda yesterday. There's no phone call. There's no discussion. No one tries to work with us on this.
Everybody's been trying to work with you from the very beginning on all this stuff, and everybody has worked together.
All right, let's get started. On the record, this is a time set for a discovery hearing in the case of Wren versus Affinity Lifestyles, case number A-21-831169-B. I'm Floyd Hale. For you counsel that are going to be participating today, when you first speak, would you please identify yourself and who your client is for the court reporter? And this hearing includes the Wren case and all of the coordinated cases. And I'm not sure the total we're up to now. I know we have two more to add. And I had three agendas to go over today. I had mine, and then I received the plaintiffs and the defendants in the last couple of days, but they're all pretty similar. So the first thing I had on most of the lists, including mine, was the testing protocol. I know the parties are still working on it. Has that been finalized yet?
No, we sent, they sent us the one that's attached here, and we sent our comments back yesterday.
Yeah, our preliminary. I haven't had a chance to go over it with the other plaintiffs' counsel, and I understand it's the same. Not all defense counsel has had a chance to weigh in, but at least we got a preliminary proposal and preliminary responses back.
Sure, no, that's good. Just why don't you keep pursuing it, and I'll set another hearing in 2 or 3 weeks, and if it's approved before then, just issue a notice in the lead case. And here's the final draft approved by everyone. On most of the proposed agendas, including mine, I had to cover the remaining cases to be coordinated, and at one point I had 4, but I think we're down to 2. Does anyone know?
That's right. McGovern and Way.
Yeah, McGovern and Way. Are those the last 2?
Whose cases are these?
Way is yours.
Okay, well, good. That'll be easy.
Way we just filed, so we're trying to get acceptance of service from everyone, and we'll move to coordinate as soon as we get.
WEI. That's case number A-20-85614-7B. And McGovern, did you say that's
Nettles
still?
firm.
Whose firm? No.
Nettles firm.
And that's still in the process?
Yeah, they got to get the bankruptcy stay set aside, I think, on that one. It just happened. It's likely.
Score, that's case number A-22-855903-C. Let's talk titanium rods. Have we located all?
No. We have been trying to figure out what was taken by the FDA. Have a listing of it, but does not include titanium rods. So I'm not sure if they've all been accounted for or not.
Are they, who has possession of them right now, your client?
No.
Yeah.
Plaintiffs
You-
do that.
It's in your warehouse.
I think
We have two.
they're really a set. So there's 2 that we have that were provided by Real Water, but in John Marlowe's deposition, he said he originally gave Real Water, he thought 10 or 12. So we just were inquiring of whether those other titanium tubes are still in Real Water's possession, and if not, if there's any accounting as to what happened.
Yeah, because when we did the site inspections, we looked for them.
Don't know.
Who's your contact at Real Water?
Blaine and Brent Jones.
Very approachable.
Yeah, I've spoken to them. They think the FDA took them, but I have a accounting from the FDA that doesn't list them yet. So we're still trying to get to the bottom of it.
Guess we will have a hearing every 2 weeks still.
We're trying to get an answer
We
on
really
that.
need to get those. Well, from the plaintiff group, do we start a protocol for non-destructive testing of those?
Well, that was one of our comments on the testing protocol that circulated. This is a destructive testing protocol, so we thought there should really probably be two different protocols, one for non-destructive, one for destructive. Like, for example, this has a provision about you have to keep remaining samples if you're doing destructive testing, but that wouldn't apply to non-destructive testing. So that's why we think there should be two different protocols. So I guess the answer to your question is no, we don't have a non-destructive testing protocol yet.
Yeah, I had on my suggested agenda non-DT, and then I noticed when I received the plaintiffs, non-destructive, but constructive. So are we supposed to at least finalize the non-destructive protocol?
I would hope so, but we have, because there's really nothing controversial about the non-destructive one. I think.
Joel, if you had a chance to look at that.
What I understand, I just want to take the titanium tubes and do some kind of X-ray diffraction, something, just to see if they're made out of titanium or something else. And rather than
Let's see, the next on my agenda, if you think I'm skipping some of the agendas you suggested, I'll get to everyone. I'm just kind of working my way down the ones I did originally. And my next agenda item is, there was an order issued June 15 for the plaintiffs to provide the computation of damages in 30 days, if possible. I understand that it's a little excessive. Where are we? Has anyone done an audit of how many of the plaintiffs have provided, or have any had a chance to?
I think we provided all of ours. I don't know about the other plans.
Yeah, Floyd, this is Jim Neale from UNFI. I think from our perspective, we've got computation of damages from all of our plaintiffs. We would ask that those who are claiming lost wages include that information. Right now, I think the computations we have consist of just past medical bills. And we appreciate that, but I don't know that they're complete yet.
Well, when we have the next hearing, that should have been included. So when we have the next hearing, just keep me posted as to what plaintiffs, if any, were missing computation of damages, and then we'll just have to go through the plaintiffs to find out if they have a wage claim, it should have been in there.
Well, there's two different lost wages that we've advised our clients about. Any work that they've missed as a result of them being sick, and then any potential loss of future earnings or issues with that. We asked them to provide the information. We've disclosed any computations that we've been able to at this point. We're going through it with them as we fill out the plaintiff fact sheets. So a lot of them, I think, are not going to have lost wage claims, at least as we know right now, without additional expert opinions and evaluations. And so we will confirm that with the plaintiff's fact sheet if we don't have anything, or if we're not pursuing it right now with respect to those plaintiffs. If we are, we'll supplement the loss of the computation of damages with loss of past earnings to the extent we can, and we'll provide them with releases with respect to those plaintiffs.
Yeah, it's kind of like if someone was in the hospital for 4 days and they missed 4 days worth of employment, and maybe they used their vacation. In theory, they do have a computation of damages claim, right? Is that really worth digging up tax returns and all this other kind of
Sure,
stuff?
Joel didn't think so.
we want to see the damages. No, kidding.
Well, there'll be a cutoff.
Yeah.
We're going to have a cutoff. At some point after the next hearing or so, when we confirm, to the best of our knowledge, every plaintiff has submitted the computation of damages. I'll give everyone probably 4 weeks to amend, and after that, no amendments absent leave of the special master of the court. Okay. This is one I missed. I hadn't thought of this, but I think plaintiffs raised it, and that is, where are we with Holo doing the subdirectories for the personal injury claimants?
I think they've got it all set up. I don't know if it's working because none of the defense have accessed it yet, but I think it's working.
So I talked to Jim from Holo today about it. We've disclosed all the defendants in each case who should have access to the individual subdirectories, which Holo has created. To the extent we left someone off by mistake, just contact me and, we'll address it. I've already been contacted by a couple people. It got a little confusing with multiple attorneys representing one party and third party claims, but we're working to get everyone authority who should. And then what Jim said was, once we've given you authority, the way to access them is the individual attorneys for the party need to contact or have someone in their office contact Holo, and they will give the instructions on how to access the individual subdirectories. So we had to do the same thing. We contacted them and they sent us. I don't know if it's a new link or if it's a password. I'm not exactly sure of those details, but you have to contact Holo and then they'll tell you what you need to do to get access.
Well, there's not that many plaintiffs. Can we get a published list of the subdirectories and who's on the subdirectories for each claimant? I mean, Holo should be able to do that, right?
We have that. We've disclosed it in individual disclosures who in each case can have access, and we've provided that master list to Holo. It's not a issue of the list. It's just some issue with Holo. The way they have it set up is you have
gaining access.
Yeah, they have to. There's another step. They have to give something to you so you can access it, and they have the list. So if you contact them, Holo will say, okay, you're on the list for these plaintiffs. This is how you access.
Like getting in the Dropbox or something.
Yeah, something like that.
All right, for you defending parties, why don't you give kind of a test flight to try to get some of the information, even if it's not all, or at least to get the procedures set up in your office. And if anybody's having any trouble, why don't we raise it at the next meeting in a couple of weeks?
Sounds good. We have a meeting with Holo tomorrow to go over it, so we'll let Eric know if there's any issues.
Hi, this is Colt. I have a question on that. Is that set up by plaintiffs individually or by plaintiffs as a group by complaint? Because it's hard to tell based on what's in the 16-1 subs we got.
It's set up by group in the complaint. And the reason we did that is even though maybe one plaintiff, for example, is suing Walgreens in the case and 3 aren't, and Walgreens really doesn't have any legitimate interest in seeing the other 3, we thought it would be too confusing trying to subdivide it. So if you're a defendant in that case, you get to look at all of them, even if they're not bringing a claim against you.
Well, if the plaintiffs agree, then
Yeah.
whatever waiver we need for that.
Yeah, we just thought it'd be too confusing to try to subdivide it again.
And what's the status? I didn't expect everything to be done within 45 days of June 14, but what's the status of getting the medical records? Anybody, any of you plaintiff counsel have an idea how you're running on that?
We've produced the medical records for all of our clients that we have in our possession. And then we are going to provide, and we've disclosed all the medical providers that we're aware of. And we're going to provide releases with the fact sheets for defendants in each case to request or subpoena the medical records directly. So all that's been done.
Floyd, Danielle Miller for Plaintiff Lisa King. We've done the same. We've disclosed all of our records and deposited them with HOLO as well as with our plaintiff questionnaire. I did have a question on authorizations. Are defendants going to be sending authorizations, or should we do ours and deposit those into HOLO?
Well, I suppose if you have a HIPAA authorization, that should be good enough.
I thought they already sent some authorizations, right?
Yeah,
There's a
Yeah.
there's a
So
defense
it sounds like the defending parties are shooting out their own authorizations.
Danielle, we'll send you those to you in the King case.
Thank you. Appreciate it.
I don't, and I apologize, Danielle. Jim sent them to me. We looked at them. I don't think we had any issue with them. But we hadn't had a chance to
I don't
look
know
at
that
it
we
yet.
forwarded them to them.
Okay.
I'll follow up on that this week and see if there's any issues. If not, I can confirm that we're good and send them around to everyone.
That's really the critical path on getting the discovery done in this case, is helping everybody, the plaintiffs getting their own medical records and the appropriate defending parties getting copies. So even while we're dealing with missing or non-missing titanium tubes, it's the medical records that are going to be the critical path on this trip. So do what you can. And it's nice to hear that these plaintiff attorneys have already produced the list of the treating physicians. Who has how many plaintiffs' lawyers does the Kemp group have?
Plaintiffs mean?
Yeah, I mean plaintiff.
57? 57?
57?
I think it's 57.
sounds right.
Oh, it was probably on somebody else's list, but I had it. What's the status, Joel, or one of the defending parties? Are you keeping track of the status of how we're doing on the fact sheets coming in?
We are, but I don't have a summary of that yet.
Well, it's early,
Yeah. I mean, I
but
could,
they are coming in.
they are coming in. Yeah.
Well,
Yeah.
now,
When
the
we-
fact sheets and the medical records will be our primary topics, with HOLO's access to those records.
Yeah, I'll know more tomorrow. We're meeting with HOLO tomorrow to go over all that.
Yeah, Floyd, you entered the order, giving everyone 30 days from July 12th to do the fact sheets.
Well, and I need 30 days from June 15 for the computation of damages,
Yeah,
and 45 days from June 14 for the medical records. Fact sheets, what did I, it was 45 days from July 15?
it was 30 days from July 15th, 12th. Excuse me. But I remember when we were here last time, we talked about trying to do some kind of rolling thing for our cases, just because we had so many. So right now, I think we have 15 done out of 57. And we're thinking that by July 12th, we will have at least another 5 done, but I don't think we're gonna hit 30.
I didn't even write down the deadline for fact sheets, because I wrote down that, and these were, I thought, pretty tight, but I wrote down 30 days from my June 15 order, the damages, and 45 days from an order that was issued the day before, June 14, for medical records. You say I only gave 30 days from July 15 to the fact sheets. I
July
didn't
12th.
From July 12.
Yeah, and that's,
Those were,
like I said last time, it's kind of problematic when we got
Right.
57. So we've got 15 done, thinking I'm gonna hit 20 by August 12th. The problem is just there's a lot of people, and summer is not the best time to be chasing people.
well, what I'm going to do, I'll kick out an order saying that the parties should continue to work toward these deadlines, but the final date for the production of all these things will be held in abeyance till further order. It was really just to get the ball rolling.
Okay. Yeah, I mean, I can get the first group out. Like I said, they're already done. First 15 are done. And it's probably a better idea to start getting them filed, and we can start going into alleged deficiencies and, start going through that process.
Well, I do want people to know those, although they read like orders, it was more of a guideline, but especially when you're talking about medical records, to get that stuff done. For those of you in the Zoom, does anyone have more than 10 plaintiffs in the Zoom?
Any plaintiffs' counsel, Floyd?
Yeah, a plaintiff's counsel. Is there any plaintiff's counsel that has more than 10? Okay. Well, I don't want you to get too worried about these deadlines. We've actually, approaching the end of some of them, but I'm really going to kind of hold those in abeyance until we get a better audit of who's produced what. So we'll have another hearing in about 2 weeks. At that time, I'd like the claimant and plaintiff attorneys to let me know the status of their produced fact sheets and their, when I say medical records, why don't we shoot for produced medical providers?
Yeah, we've actually already produced most of the medical providers because we did 16-1 supplements that have that information on them.
So for those of you,
We've done that for all 57 cases too.
did you say 57? I thought it was 47.
57.
Well,
You just got 10 more plaintiffs?
Well, we had 50,
except for the new,
except for the new ones, yeah.
Yeah.
New ones.
So again, for those of you helping me through the Zoom, in the next hearing, try to have an update, kind of an audit of the plaintiffs that are produced, how many you have, how many have produced fact sheets, how many have produced authorizations and medical records. Because there's not a whole lot we can do until we at least get, 80% of that done. Oh. And then the plaintiffs, Joel listed on their agenda the affinity responses to written discovery.
Well, that's not actually an affinity because we really haven't sent any to Real Water. But
Oh,
we're waiting.
status of defendants' responses.
Yeah, that's the only defendants we've sent discovery to are Walgreens. They filed an answer and we had a meeting. We had a meeting confer with them, and they're supposed to be doing something, trying to get further information.
Walgreens said they had no documents.
Well, when we had the supplement, when we had the meet and confer, they said they had no real water, period. But there seems to be some confusion, at least on our part. I don't know about Walgreens' part, but on our part, there's some confusion about the manufacturing codes and everything. So we've talked to Joel about that. We're going to try to get more information to Walgreens and do a better dive on that.
And I'm sorry, I don't remember who represents Walgreens.
Uh,
Are they with us?
yeah.
Jason Fowler.
Yeah, Jason Fowler. I don't know if Jason's on. Yeah, we had a court reporter at the meet and confer, so we'll have a transcript. And then
I thought at one time I saw their initial responses. They said they had no documents.
yeah, they said, well, not only do they have no here's their initial response. Not only do they have no documents, they had no real water, according to them, which we don't think's correct, but I think the problem lies in these codes.
Yeah, the scan codes that we're talking about. For those of you probably haven't had a chance to catch up on your reading, including all the discovery responses. Walgreens said they had no records of any sales captured by scan of the UPC codes on the real water products. So
Of the recalled real water product.
Yeah, the recall.
So I don't, we got to go look and see what the recall code was. And then we got to see if there's other codes, try to get all the codes to Walgreens and do,
well, wasn't it all recalled?
well, yeah, but the recall code, the one in the recall didn't have all the codes. We know that.
All right, did I miss a topic?
Okay, I'm sorry. Well, this is Colt. I want to jump in on that Walgreens issue. As you know, in my answer in the Bonner complaint, denied that we had distributed water. I've produced my list and the stuff are in the invoices, and also in our initial disclosures produced the distribution agreement we had with Walgreens, which I think with the exception of Whole Foods.
You said distribution agreement with Walgreens. You mean real water?
I'm sorry,
right?
just distribution agreement with real water, that with the exception of a few retailers, Whole Foods, and I believe Sprouts, and maybe one more, we're the exclusive distributor. So to me, Walgreens' response to the interrogatories was consistent with our understanding, having not distributed to them.
I thought from your answer, you said you distributed to them up to a certain time period in 2018. That's the way I read your answer. Maybe I'm wrong.
No, I think that's right. And if your client purchased it in 2020, that's
Right, but see, that's the problem. Walgreens claims that they've never sold real water. So if you're saying you sold it to them through the middle of 2018, and they say they never sold real water, there's something's wrong here.
Is there a central,
Probably why they did not.
is there a
order.
central area where these records for Walgreens are reviewed?
Well,
Or is it done regionally?
yeah, we don't know. The distribution agreement that he's referencing has a clause in it that says that if someone's a national distributor, which they define as being 50 stores or more, which clearly Walgreens is a national distributor, that upon agreement between Nevada Beverage and Real Water can go straight to the national distributor. So we think that's what happened here sometime in 2018. But all we know is what he just said, that he was selling it to them before 2018, and they claim never to have sold it.
And I assume you're still working together trying to resolve.
Yeah, we've had a conversation with Joel about codes, and we're sending another set of interrogatory to Nevada Beverage, or a set of interrogatories to Nevada Beverages, part of which is trying to address this Walgreens issue. And so, yeah, we're trying to get to the bottom of it. But I you know, I mean, in defense of Walgreens, okay, the way I understand this is Real Water either gives it to Nevada Beverage or one of these other big middlemen distributors. So it's not like the Real Water truck is going straight from the plant to Walgreens.
All right, were you trying to get a hold of Jason Fowler? He's here.
I'm in now. Sorry, I had a missed error on my calendar. I thought this started at 2. I apologize.
That's all right. I thought it started at 2 also.
But anyway, so that's where. Go ahead, Jason.
Yeah, just to clarify, I only caught part of what you were saying, but I think our to be clear, our position is that we, as far as we can tell, have never sold it from the store we were asked about. And so I'm following up, and Will and I had reached an agreement that we would provide a supplemental response within 15 days. Because I understand Nevada Beverage's position that they sold it or distributed it to us, however you want to phrase that, back in 2018 up until May. But we don't have any codes in our system that show that we ever sold it.
Oh, I'm sorry, I missed a topic on my list, and that was, what's the status of the plaintiffs amending complaints to bring in new parties?
Yeah, before we get to that, just for the record, we have served 2 other sets of written discovery requests, one to Hannah and one to Milwaukee Instruments. In Milwaukee, we gave a 15-day extension, and I think last week they wanted another 15 days. So they've got an extension. And Hannah, can't remember exactly when that's due, but as we speak right now, those are the only 3 sets we have out.
I just told counsel for Hannah, I'm not sure they knew about this. They might be on in a minute. That's Michael Nunez.
So the 3 you served were
Walgreens,
Hannah,
and Milwaukee Instruments.
All right, so I'm sorry that we kind of jumped back and forth there. Where are we on the status of amending complaints to make sure we have all the defending parties?
So we've drafted proposed stipulations to grant us leave to file amended complaints in our cases. We sent them around. We've heard back from some, but not all the parties. And we did follow-up emails today, so if you haven't responded to those emails, if you could respond with any issues or with your agreement, and so we can get those on file as soon as possible.
And those will have to go through the individual departments for the orders.
Eric, can I ask a favor? If some Nevada beverage, and I'm not joined in all the cases, if your proposed amended pleading proposes to include me or join me as a defendant, can you include me on those just so I can keep track, please?
Yes, if we haven't done that already, I'll make sure that we do.
Thank you
And
very
any-
much. I know you don't need my signature, but it just
And
helps
for
me keep
those of you who may have missed it, no, Cole probably knows, but we're using Wren, the Wren litigation as the kind of what would be a lead case in a consolidated action, although this isn't consolidated. So you should all be monitoring, get on the service list for the Wren case. It's Christopher Noah Wren versus Affinity Lifestyles, case number A21-831169-B as in boy. And you really need to monitor that because otherwise you're going to have to monitor 14 or 15 cases. And when I do a notice, we're trying to do the notice to each case, but the notice of a hearing will always go to Wren. So if you watch Wren, you'll get all of my notices. All right, that amending the complaints was the last thing I had. Is there anything else we need to cover today?
We have the Castillo deposition.
Right.
We talked about the Castillo deposition that was set. It was continued, I believe, until August 10th. We were still in the same situation we were when you continued it. The documents have not all been produced. No one's had a chance to go through all the documents. So it just seems logical that we would continue the Castillo deposition one more time, at least another time.
I have another agenda list here. I buried it. It asked to go over the August 10 Shana Castillo and real water document production issue. So,
Yeah, I don't mind kicking it, but I mean, this is really low-level person. The only reason we're doing, this is like a preseason game, okay?
The
Yeah,
descriptions of poor Miss Castillo's job before.
yeah, she was allegedly the head of production, but, you know, best we can tell, she was 20-year-old high school grad, just made the head of production. So we're not expecting her to really know that much, to be honest, but.
And we'll get into the same argument as I recall, as Kemp said before, we can always file a motion to take it again if the facts support it.
Yeah, I don't mind kicking it, but you got to get started someday, you know?
I think we are getting started.
Well, we're not going to finish it one day anyway, are we? Well, maybe.
Yeah, I think it'd be a one-day depot. I think my examination would probably be 3.5 hours at best. And that's just because spending a lot of time going through the organizational chart and who's who and what's what.
I think we just still need to have the opportunity to look at the documents. I mean, I understand what he's saying, yes.
I don't think
Give me
there's,
some proposed dates for that deposition at the next hearing.
What I'd suggest is like we did the last time, rather than give you a proposed date, I mean, Mr. Kemp,
I don't mind kicking it back 2 weeks. I mean, I don't have any problem doing that.
I think we need to have the next status hearing, make the determination if we can go forward with it, because things are getting set up. Polo's getting set up and the
Yeah, but
opportunity is there. but-
what we're having here is plaintiff, interrogatories, you know, and then we're gonna have deficiency letters, and I can't take a low-level real water employee
We're going to
deposition.
have to start with some of these depositions. And if they have to be taken again, they're going to have to be taken again. And probably they'd be reopened for some of the other parties anyway.
I mean, I got the burden of proof. I'm prejudiced
So
more
it's
than
not a
anybody.
matter of if we're going to take the Castillo deposition. I just want to know how soon we can get there.
What I'd suggest is, again, I mean, if he wants to set it, great.
It is
But I
set.
wouldn't set it, I mean, I think we should continue it. But at the end of the day, why continue it another couple weeks when you can set it out maybe?
What I said was when I had my hearing, I'm going to have a hearing in about another 2 weeks. I want potential dates for the deposition.
How about,
Not, we're going to discuss whether it gets taken again. We're going to if you think it's 6 months and he thinks it's 2 weeks, I'll deal with that. But this will be the third hearing on this depot.
I understand, and the thing that I'm concerned about is if we've got such a low level employee, what's the big deal?
Well, the big deal
Exactly.
is you got to start somewhere. That's why. I mean, if you will agree right now to suspend all plaintiff discovery obligations until we do the Castillo deposition, that's a fair offer.
All right, we're going to talk about the Castillo depot at the next hearing. I want the defense and the plaintiffs' suggestion as to how soon that can be taken.
Well, she's not employed by them anymore. I have to go serve a subpoena on her, which I already did. Yeah, so this is not, yeah, this is not a, now I got to go through and try to serve her again.
I think your suggestion is that we're able to work with them to set a date.
Well, what kind of work is this? This is on the agenda yesterday. There's no phone call. There's no discussion. No one tries to work with us on this. They just.
Everybody's been trying to work with you from the very beginning on all this stuff, and everybody's worked together. So to pull this out now and say, no one's working with us, that's not correct.
I agreed to continue it.
What do you think you need before? We've got a court reporter, so we don't want to talk over each other. And if I'm talking, that means I want everybody else to stop for a second and help me out and help the court reporter out. But as of today, how much more discovery do you think has to be accomplished before we take this witness deposition?
Here's what I'd suggest, because we got a number of attorneys and a number of cases involved in this. And as you have suggested, let us sit and talk with the law firm, with Eric and Will, and figure out a date where we're all agreeable. And then we have 2 weeks, we've got another hearing, and we can give you the date at that time.
Yeah, but the predicate there is they want to review all the real water documents before I can depose this person. Okay, that's their starting point, and then they want to send them to their experts. So basically, they don't want me to take any real water depositions for 6 months. That's really what's going on here. And I'm the one with the burden of proof. He's not prejudiced,
This is an ex-employee, and what was her title? You said
Her title was production manager, but I think she's a glorified production manager at best.
Well, I want to get her deposition on calendar. I don't want to wait a half a year.
Then, as you have suggested, and we've talked about, why don't you give us until the next session in 2 weeks?
I just did.
Okay, great.
Yeah.
Thank you.
Well, Floyd, I'd like to at least
I got lost in translation.
serve another notice of deposition on her and get it reset, because I have to get the process server out there. And next thing you know, we're going to agree to a date, and then I won't be able to serve her.
Who did she work for?
She worked for Real Water.
And when did she quit working for Real Water?
Oh, probably about 2 years ago.
Probably when the whole thing.
I think she was gone before the outbreak.
Losing her. Does anybody know where she is now?
She's a longtime Nevadan, so I'm not worried about her moving out. But you never know.
We'll work with them. We'll have it for you, the next status here.
Okay.
Well, if we do it the next status hearing, then then it's 15 days out. Then they're going to yell and scream about it. Why not just let me move it to 8/24? That gives him another 2 weeks to do what he should have been doing already.
We have been doing it, and he's getting moving at 8/24, and at the end of the day, he's
You've
talking
been
about.
doing what? You've been looking at the Real Water documents?
He's been talking about being prejudiced. We've just now talked about Holo being set up and being able to get to them.
Holo doesn't have anything to do with the Real Water.
She doesn't need to know, you don't need to know about medical records to.
Only thing I'm saying is let us work with him, and he can notice it. She's a longtime resident of Nevada. She's not going away. It's a situation where there's no harm here.
I see no harm in taking the deposition. If he comes up with some document later on that's a scathing, incriminating document that she wrote, he can take the deposition again. I won't oppose that.
All right, we're going to have a hearing in 2 weeks. At that time, I want to hear what the agreed date is for that depot or the potential dates for that depot. And if it's agreed to in advance of that hearing, serve the subpoena.
We're going to be right back where we are because they have not looked at the first real water document yet. They haven't sent it to their experts yet. They're going to come in and come up with this big.
I'm not convinced that's a prerequisite to this deposition.
When we were here last time, 2 weeks ago, I indicated we're gonna get right back into the same situation we went through 2 weeks ago, and it's just the same thing all over again. So I think the courts.
It is the same thing all over again because
It's good.
if you guys want to look at the real water documents, go look at the real water documents. That's not my problem. You haven't done it. All you ask is
I want the
delay.
dates for her deposition, and if we have to take it again, I can't imagine that we need all this discovery done for an ex-employee's deposition.
Yeah, this is not Brent Jones. This is not, someone like that. This is a low-level employee.
So in 2 weeks, we're going to set, if the depot isn't set, in 2 weeks, I'll set it. Now, whether it'll be 3 weeks away or 6 weeks, I don't know.
Floyd, just for clarification, what you said just now is a little different than maybe what I heard, so I just want to make sure I understand. In 2 weeks, we're coming back for special master hearing to provide you with dates for this deposition, correct?
That's one, yeah, with potential dates to
Okay,
take the deposition.
Just want to make sure I heard correctly.
Yes.
Okay,
And, but if you agree in advance,
then we can just go.
you can move forward. You don't
Okay.
need my approval.
And if we
Okay.
don't agree, you'll set.
If you don't agree, I'll set it.
Okay,
I'll give you a window to set it,
Thank you.
like a week or something. Just a minute, what else?
so you had the production of the real water document.
Yeah.
That's something we've not talked about. Chime in.
Yeah, that's the next item on the agenda we received yesterday.
So, a couple things. There's going to be a rolling production. We're meeting with Hollow tomorrow. The initial production should start tomorrow. Supplemental production. The insurance has all been produced. These are actual documents. There was a glitch with the documents, and somebody had inadvertently held back too much in privilege log. And I looked at it, and right now I don't see any privilege documents. So those need to be put back into the production. It'll go out tomorrow. Then we'll be doing a rolling production of the Henderson documents first, just because those are in the possession of Hollow, and then the Mesa production. The Mesa documents are scheduled to be picked up from the Real Water warehouse on Thursday, and we'll send a letter out to all parties if anybody wants to go watch the truck, pick the documents up and take them from the warehouse to Hollow. They're welcome to do that.
When do you think the Henderson ones will be available?
The Henderson ones the first batch will be ready tomorrow. The second batch, it'll be a rolling basis. Basically, the only thing being held back currently is social security numbers or private information from people, because we have, for example, resumes of people, and there are, I don't know why somebody will put a social security number on a resume. Some people did. Don't know why. Things like that are being redacted, or if there's a direct deposit bank account information, that'll be redacted. But other than that,
So when
so far,
batch two will be up? When do you think batch 2 will be produced?
we are shooting for next week for batch 2. Got 3 paralegals working on it, and it'll be a rolling production after that. The second batch should be pretty quick. We've already gone through that, and then after that, we will be on to the Mesa documents.
Okay, but we'll have all the Henderson ones by,
We're shooting for the end of next week.
so 8/12 probably.
Is that Friday of next week?
Yeah.
That's what the paralegals have told me. I haven't personally looked at them.
Okay, and what kind of volume are we talking here?
It's quite a bit.
10,000 pages?
I could find out for you and let you know.
Okay, just
Don't know.
curious.
Are they electronic or are they in file cabinets?
They've already been scanned by Hollow, and they're in Relativity.
Now, the Mesa facility's been completely cleaned out, right?
Right. Well, Has it been completely cleaned out? We left, there were some machines we left down there.
Somewhat machine.
Machine, yeah, it wasn't completely cleaned out.
My understanding was that some of the equipment are subject to UCC liens and security interest, that they were pushing them to an area of the warehouse and then trying to re-rent the empty space. So there's still equipment there, and I don't know what they did with the boxes and the water that was there. I assume they're disposing of it.
Yeah, I would say as far as Mesa goes, if anybody wants anything from Mesa, they better speak up now.
Well, when was the inspection and the pickup? About a month ago?
Yeah, it was over a month ago because the stuff is now in the Henderson facility.
Well, the landlord down there he's not getting paid, is he?
He's trying to re-rent part of the building and he's moving the real water stuff to the other part of the building, waiting on the ability to destroy it. It's all going to go in the trash.
Is this the Mesa person?
Yeah.
Mesa person.
All right, we'll set this up again in another 2 weeks.
Quick question on the
We'll
real
call it
water
the Castillo deposition notice hearing.
production. I'm not sure what the status was, but there were some prior documents that were disclosed on the notice of compliance, but held back pending protective orders entered.
Yeah.
Has any documents that were held back been produced?
Those are being produced tomorrow because some of those were inadvertently put on a privilege log and they don't belong to the privilege log.
The FDA list,
The FDA documents are in there.
no, the list of what you gave to the FDA or the.
That is in there.
Okay,
That was one of the ones somebody thought back and
okay.
it would be there, but it's not as exciting as I had hoped. It's just a listing of water that's taken.
The FDA to volunteer.
The client wrote down a handwritten list when they were there, and that's what I have.
Hmm. Hmm.
I'm waiting for the pen to drop over there.
Just thinking we're missing something on these real water documents. I can't remember what it was.
So the real water documents in Henderson were in a file cabinet. Those were taken and scanned by Hollow.
Mhm.
That'll be in the second production.
Okay.
Let me double check my 3 agendas.
And that's got the batch logs and everything?
Not that I've seen. I haven't seen batch logs in there.
In either production?
Correct, not in either.
Okay.
I think those documents were from Mesa. It seemed like Mesa was where the,
Didn't Akins testify that he had batch logs that he prepared when he was making batches in Henderson?
maybe. Yeah, maybe I misspoke. Maybe those are in there.
Yeah,
I'll know when I look through them tomorrow.
okay.
All right, does anybody have anything else, including all you folks on Zoom? Can you hear us okay up there? On
Yes,
Zoom?
we can.
Loud and clear.
Yes.
Because we have mics all across the table, so I was hoping you would be able to.
Floyd, this is Tracy. On the King matter, I wanted to point out that on July 28th, we did file an amended complaint at bringing in Milwaukee and Hannah, just so you're aware.
Okay, thank you.
Yep.
And is anyone missing a protective order? I signed them all today. I got them and notified the people, the attorneys pick them up. Is anybody still missing a protective order or needs to get one to me?
This is Jake Smith on the Vinciletti case. I think I still need to circulate one and get that to you, but it's on my list.
Okay. All right, anything else?
Yeah, I don't have the names if there's 19 people here. I have no idea who's online.
I'll see what I can get for you.
Thank you.
If they didn't speak, I'm not concerned about it. I just want to make sure our record is good. So we'll stop by our front desk. I wasn't hosting this. All right, anything else? All right, we'll get together in about another 2 weeks. Thank you.
Okay.
Thank you.